Supreme Court of India 2023 INSC 955 Bhisham Lal Verma vs State of Uttar Pradesh and another decided on October 30, 2023. Facts of the case. Complaint dated June 23, 2012 was filed by the Joint Director, State Urban Development Authority, Uttar Pradesh, before the Station House Officer, Police Station Kotwali, Rampur, alleging irregularities in the construction of toilets under the Integrated Low-Cost Sanitation Scheme and embezzlement of public funds by the persons involved. CC number 1280 of 2012 was registered under sections 409, 420, 467, 468, 471 and 120B IPC read with sections 7 and 13 of the Prevention of Corruption Act, 1988. The petitioner was amongst the accused named therein. Under Section 197 CrPc and Section 19 Act, the government of Uttar Pradesh accorded sanction to prosecute the petitioner. Upon completion of the investigation, charge sheet dated April 30, 2015 was laid before the learned sessions judge, Rampur. The petitioner was charged and sessions judge took cognizance with offences under Sections 409, 420, 467, 468, 471 IPC and Sections 7 and 13 of the Act. The petitioner filed his first petition under Section 482 CrPc, challenge only the government sanction order dated December 3, 2013. The High Court disposed of the application, vide order dated December 15, 2020, granting liberty to the petitioner to approach the trial court and challenge the sanction order. In the year 2022 that the petitioner felt inspired to file a second petition under Section 482 CrPc, to quash the charge sheet dated April 30, 2015 and the cognizance order, dated June 12, 2015 and the proceedings insofar as he was concerned. High Court noted that it was not open to the petitioner to go on challenging the proceedings one by one, and as he had not felt aggrieved by the charge sheet or the order of cognizance when he had filed the first petition under Section 482 CrPc, the High Court concluded that the subsequent petition challenging the same would not be maintainable and dismissed the application. Findings of the Court: no blanket rule that a second petition under Section 482 CrPc would not lie in any situation, and it would depend upon the facts and circumstances of the individual case. It is not open to a person aggrieved to raise one plea after the other, by invoking the jurisdiction of the High Court under Section 482 CrPc. Though all such pleas were very much available even at the first instance, permitting the filing of successive petitions under Section 482 CrPc. Ignoring this principle would enable an ingenious accused to effectively stall the proceedings against him to suit his own interest and convenience, by filing one petition after another under Section 482 CrPc, irrespective of when the cause therefore arose. Such abuse of process cannot be permitted. In the case on hand, the filing of the charge sheet and the cognizance thereof by the court concerned were well before the filing of the first petition under Section 482 CrPc, wherein challenge was made only to the sanction order. That being so, the petitioner was not at liberty to again invoke the inherent jurisdiction of the High Court in relation to the charge sheet and the cognizance order at a later point of time. Impugned order does not warrant interference. The special leave petition is dismissed.